Wolf Theiss Soundshot. Insights and analysis from one of the leading law firms in Central, Eastern and Southeastern Europe.
Hello and welcome to the Wolf Theiss Soundshot Podcast, Digital Law Edition. My name is Roland Marko, and together with my dear colleagues, Paulina Pomorski from our office in Vienna.
Hi, and welcome from my side.
And Ihasz from Budapest.
Hi, everyone.
We are happy to present to you our next episode of this podcast series with practical insights about the rapidly changing digital law. This time, we would like to take a look at the Data Act, which is yet another cornerstone of the digital strategy of the European Union. We all know that the volume of data we generate has been increasing exponentially. And at the same time, not much of the data have been used to the fullest extent it could be. The Data Act now is a pioneering regulation which establishes a framework for data access and use and sets rules for deriving economic value from data. We can expect far-reaching implications in many sectors of the economy, and it will create new business opportunities driven by data, we expect. But it will also require companies to review how they manage their data and make changes to the design of their products and services to ensure that data can be easily and quickly shared. To achieve this, they will also need to create adequate internal processes and policies, obviously. But just to set the scene now, Paulina, could you please tell us in a few words about the key points of the Data Act?
Firstly, the Act regulates who is authorized to use and access the data, which is generated by users of products or services. Here, it is already important to note that we are talking about data which goes beyond personal data, so also any kind of raw or pre-processed data. This is obviously of particular importance in the context of connected devices and Internet of Things in general. Which means that at the same time, here we can expect new opportunities for business provision in connection with access to data. Further, under the Act, the data shall be easily accessible, which we can also call in general as data accessibility by design. Further, the user should be able to move the data from one provider of data to another, and such data shall be provided in a format so it can be shared, exchanged, and aggregated easily. As another important point to mention is that the Act also provides rules for ensuring fair use of data, while at the same time stimulating competitive data market. This means that the data holders are obliged to make the data available to third parties under fair, reasonable, and non-discriminatory terms. And in return, they may, under certain conditions, also request a compensation from the data recipient for this data sharing. So here we see that the data really turns into a commodity, as we will be able to put the price tag on the data. With these regulations, also smaller companies shall be shielded from unfair contractual rules vis-à-vis companies which have a significantly stronger bargaining position. Finally, another important point is that the Data Act also provides for mechanisms for data sharing with public entities, with a view to public entities needing access to data in emergency situations, such as we all know in pandemics or other natural catastrophes like fighting wildfires or floods. And additionally, public entities may have also access to data for statistic purposes if this is in the public interest. From a timing perspective, the Data Act already entered into force this January 2024. And it will be applicable from September 2025, whereby certain provisions in the B2B context will be applicable only in September 2026.
Great, thank you, Paulina. You mentioned access to data for public entities. Indeed, the Data Act covers the full range of stakeholders, being businesses, consumers, and governments. So it has a very broad scope of application impacting different players. Peter, how is this new legal framework expected to impact business to consumer and business to business relationships?
Many thanks, Roland. Expectation is that it will have a significant impact on both business to business relations as well as business to consumer relations. However, for consumers, the set of rights provided by the Data Act will be more of a novelty, as it shall provide consumers with more access to their data as they have at the moment. This being not personal data, as consumers have access to it under the GDPR, but technical data generated by their devices. A good example for this would be that I could request manufacturers, for example, my coffee machine, to send the data on the volume of grounded coffee per month to my shopping app as a user owner of the connected product and the user of a related service, which will add coffee onto my shopping list in good time before I run out of coffee. I could also ask manufacturer to send some technical data, for example, number of cups served, to a company who does maintenance of coffee machines. And equally, the data sharing can go the other way. For example, an insurance company may ask the owner of a vehicle to provide some of the data collected by the equipment in the car to make their assessment of risks or damages and define an insurance premium. Accordingly, the owner of the vehicle may put forward such a request to the manufacturer to share such data with the insurance company as the designated data recipient. So as we see, the possibilities are really endless and open up a completely new realm of data sharing and interaction between players on the market.
Super interesting. In terms of business to business situations, then we are talking about industrial data predominantly. And an example that comes to my mind is a company that operates lifts, elevators. And practically a lot of buildings have lifts, offices, flats, hotels, shops, you name it. And if lift operators had access to technical data of the lifts, how often they are used, how heavy a load is, maybe they could better predict and plan when maintenance is required or which spare parts may need to be replaced. The operator then could be not only the manufacturer of the elevators, but also another company who does maintenance.
Absolutely, a very good example, Roland. In business-to-business relationships, companies can already now regulate contractually how they use and share data. However, new business opportunities may open up, as with the new regulation, we'll have a new framework which will allow data sharing on more unified and market terms based on the request of users of the products or related services. What is equally valid for both businesses and consumers is that customers should be able to switch quickly between providers of data processing services, cloud service providers, and providers of Internet of Things devices, and without losing any data. Customers will have more flexibility, and the burden of ensuring the smooth switching will fall onto the providers, and definitely something that they will have to consider when developing their services and products on the market.
Absolutely. Interoperability of services and between services is one of the main factors. When it comes to the assignment of possession and control over raw data, in our practice, we often see that the provider of a service or the connected product uses very broad language, largely availing itself of the possession and the exploitation rights over user data. Is there anything that will change in respect of the allocation of data use rights as compared to now?
Indeed, the Data Act will likely have an impact on the current status quo and how market players transact over their data in the future. For the benefit of our listeners, let's just clarify the data covered by the Data Act. And here I point to Chapter 2, where it is stated that business to business and business to consumer data sharing obligations shall apply to all raw and pre-processed data generated from the use of a connected product or a related service that is readily available to the data holder. For example, manufacturer of a connected product, provider of a related service, as you've noted, for example, the coffee machine or the lifts that you've noted in your example. In other words, data that can be easily accessed without disproportionate effort, going beyond a simple operation. This applies to both personal and non-personal data, including relevant metadata, which means that specific data that allows others to read and use and efficiently data that is derived from these products or services. So such data includes data collected from a single sensor or a connected group of sensors such as temperature, pressure, flow rate, and audio. Already now, many companies conclude contracts to utilize and share such data. However, few have the bargaining power of the tech and manufacturing giants we all know and recognize. Opposing such one-sided bargaining power is the reason for the introduction of the prohibition of unfair contractual terms, as mentioned by Paulina, aimed to prevent a party with a stronger position from taking advantage of the bargaining position to the detriment of other parties. And what we see as a possible impact is that the introduction of these unfair terms, these new set of regulations in the Data Act, will redefine how these players on the market will transact over the possession and use of their data. And we will definitely see some developments on how these relevant contracts and contractual relationships play out and influence the data market.
Thank you, Peter. When talking about legally statutory data sharing, one of the concerns I, as a data owner, would have is that I would largely see data as something containing trade secrets or as something that is proprietary to me. Paulina.
Indeed, that's a very valid point. And there can be, of course, concern on the side of industry players with respect to the protection of their intellectual property. In fact, this was also a hotly debated topic in the legislative process, how to balance the promotion of data sharing on the one hand with the protection of intellectual property rights from the data holders, and here in particular, of course, trade secrets on the other hand. So that's why the final version of the Act sets out certain provisions which shall ensure that the confidentiality of the shared data can be maintained and possibly data sharing can be suspended as well.
Many thanks, Paulina. If I may just follow up on this, what we have set out in the Data Act, specifically in Articles 4 and 5, is that the data holders will be able to label those data sets that represent trade secrets or they consider as trade secrets and impose obligations on data users and recipients how to use that particular data when it is shared. This can be regulated in their contractual relationships. The other limitation set out by the Act is that data received through these sharing agreements cannot be used to develop competing products. Interestingly, what is currently a debate in relation to the Data Act is that certain data sets and certain types of data included in the data definition of the Data Act may not be classified as trade secrets based on other European Union legislation. And this creates a situation where data holders may claim that the data they are required to share is considered a trade secret. However, in reality, that is something that may be arguable by the other parties. Having said that, there is a sense that the Data Act sets a quite high threshold for data holders to claim exception on trade secret grounds. And we will have to see how it plays out in practice and how the European Commission will further elaborate and allow some guidance to be available on this topic.
Very interesting, Peter. Thank you. I could imagine actually we will see a lot of court action when it comes to assessing this thin line of what data sets represent a trade secret, and especially in case such data could potentially be used for the development of competing products and services. It would be definitely interesting to see how this will end up in practice, and I hope we are on the front line in this respect. Talking about practical aspects, Peter, how will actually data be shared and made available between those players addressed by the Data Act?
Many thanks, Roland. Chapter 2 provides that the general requirement is that the data holders who are obliged to make data available must ensure that the data exists in a format that others can receive and use it. In practice, it is really similar to the data portability requirement that is actually relevant, and we already know from the GDPR. And this also means that companies will have to review their manufacturing practices, and they will have to ensure that the data they share is technically and operationally usable and actually possible to be shared. In addition, they will have to be able to manage such data sharing requests. This means sufficient resources for the administration and appropriate internal processes and policies, not to mention lead times within operations. That is also very critical so that they can meet customer needs. Certain products will inevitably have shared data sets that also include some personal data mixed into these raw data sets. Fortunately, the GDPR still prevails for personal data and will have to be considered. Here, however, we will not go into the details of this, as we will cover it in another episode. But just to point it out briefly, since GDPR aspects will have to be considered, the players who are required to share data based on the Data Act will have to account for certain mechanics or certain processes that allow personal data to be anonymized and allows such data sets to be shared between the parties.
I'm definitely looking very much forward to the next episode, then touching upon the GDPR aspects of the Data Act. Not only Data Act, but there are several others around which have a lot of interference with data protection. Coming back to Data Act, we said the Act affects everybody from individuals to companies. Which sectors and industries are likely to see a bigger impact? Peter, what do you think?
That's a very tough question. And obviously, the Data Act is geared to be all-encompassing and as broad as possible in terms of data created by the use of connected products and services. So in that sense, the spectrum is really, really broad. What we can think as examples are really manufacturers of connected services that have some sort of sensory elements that are able to read their surroundings, read certain data in terms of their operation, and also the relevant connected services, softwares, and all those ancillary service providers that enable the functions of these connected products. Some very general examples could be the mentioned coffee machines, smart fridges, smart thermostats in homes, and really the range is huge. Also, automotive industry is heavily impacted here with all the new vehicles having very sophisticated smart elements and computer devices on board.
How about companies outside the EU? Will it have an impact on them too?
Exactly. Obligations under the Data Act will fall upon manufacturers of connected products based on the EU market and providers of related services, irrespective of their place of establishment. It also means that the data holders, so those exercising control over data, can be located both inside or outside the territory of the EU.
Paulina and Peter, thank you very much for this summary of the new regulation, the Data Act, taking the view of a company. What should companies be doing right now? I mean, until September 2025, when most provisions of the Data Act become applicable, we have only a bit over a year left.
Yes, indeed. And there's a lot to do. So as a first step, obviously, a company needs to check whether their products and services fall, in fact, within the scope of the Data Act. Further on, you need to determine what data you have and whether this needs to be shared with third parties. This means also that you have to check whether the data in question is possibly protected by confidentiality obligations or, like previously described, intellectual property, which can be subject to exceptions. As a next step, companies would then also need to check whether their services and products fall under specific industry regulations and whether, in this context, these need to be aligned. As a next step, then, if this has been determined, companies then have to look how their products and services need to be modified so they are able to specifically share the data. This means that, for example, a technical possibility needs to be implemented to extract or reproduce such data, to store it, to anonymize it if necessary, and of course, as already mentioned, to make sure that any confidential data is excluded. As a next step, it is also important for the organizational part to draft and implement internal policies and processes and procedures, how to deal efficiently with requests for data sharing and to comply with the requirements of the Data Act. And of course, hand in hand with that goes the required training of staff so that they are able and ready to deal with requests in an efficient and compliant manner.
It looks like this is really quite a lot of work to be done and ahead of companies, from strategic considerations to technical adjustments, planning of resources, internal legal implementation, you name it.
Indeed. And like you just said before, there's only a little bit more than a year left. And having said that, we have to remember, of course, that this is not a one-off exercise. This means that companies have to regularly review their data management practices for compliance and efficiency. And on the other hand, we also need to keep an eye on any updates from the regulator. At the moment, it's not clear who on the national level, at least in Austria, these will be. It's an ongoing process.
Good point. And in case you are non-compliant, what about enforcement and penalties? Are there any?
The enforcement will be done on a member state level, and we are currently looking at our legislators and authorities to see whom they will designate as the main enforcement body. Chances are really good that the data protection authorities will be the ones allocated to this duty, as they have the most experience and competence in data-related questions, but this is something still out in the open. In terms of penalties, unlike the GDPR, the Act does not link them to revenues or establishes a relevant ceiling for them. Penalties will also be the responsibility of national authorities in the member states. What the Data Act provides, however, is that penalties and fines that local member state authorities will impose must be effective, proportionate, and dissuasive towards those who do not comply. So we are of the opinion that penalties and fines will be substantial.
Yeah, the same wording we also know from the GDPR and the enforcement, so we can reasonably expect to develop things into a similar direction. Thank you, Peter. I think we have now covered the key points of the Act, and to conclude, I would like to say that we have to see how it works in practice and how it supports the growth of the data economy as intended by the regulator and the EU legislator. What we can say for certain is that there is a lot to do already now for companies in and outside the European Union. It is such a complex and manifold piece of legislation that there will unavoidably be questions, and we sure will need to look into more detail in various aspects of it, not only from the technical but also from the legal aspects. We hope to conclude that this episode gave some clarity on the main points, and together with Paulina and Peter, thank you for listening, and we are very much looking forward to discussing these issues further.
Thank you.
Thank you.
Thank you for joining us for today's episode of Wolf Theiss Soundshot. For more information, you can contact us via email at soundshot@wolftheiss.com or visit our website at www.wolftheiss.com.